Howdy, I'm Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of a crime in the Woodlands, Houston, Conroe, and that general area. Today, we're back in the news. I wanted to talk to you about a legal issue going on with Merrick Garland, who is the United States Attorney General. That's the Department of Justice. It's like the head law enforcement official for the federal government. He was appointed by Joe Biden. He was previously a circuit judge on the United States Court of Appeals for the District of Columbia. And so Merrick Garland, if you don't know who this is, again, this is the guy that President Obama tried to appoint him to the Supreme Court near the end of Obama's term. He was blocked by Republicans so that they could hopefully, get a different party president. They did. They got Trump, and then they put in Neil Gorsuch, who is now on the Supreme Court instead of Merrick Garland. And so Republicans at the time were warning, okay, well, Merrick Garland, he's probably just an ideologue and would be a bad addition to the Supreme Court. He doesn't really want to uphold the rule of law. He was probably a more centrist pick, honestly, because Obama knew he had to try to get somebody in with a Republican Senate at the time, which is going to be difficult, but has happened in the past. And so he tried to appoint Merrick Garland. Didn't work out. Biden gets in, and instead of going to the Supreme Court, Merrick Garland becomes the Attorney General of the United States. And so Merrick Garland is, supposedly very non-biased. I kind of felt like a decent pick for Attorney General of the United States. It's going to be somebody who's a Democrat or more liberal, but this guy seems to be a reasonable pick. He's been a judge for a long time, certainly knows the law. He went to Harvard undergrad, Harvard Law School. So that's a little bit about Merrick Garland. So what's been going on with him in the news recently is he sent out a memo that told the FBI to basically, and the Department of Justice, United States Attorney's offices, to partner with local law enforcement, including federal, state, local, tribal, and territorial leaders within 30 days of October 4th and discuss threats that were happening to school administrators and board members and teachers. Well, if you've been paying attention to the news at all, you know that critical race theory has been a hot button issue. Is it being taught to children? What is being taught to children? Is there any type of education programs out there that say certain children should be sad or feel bad about themselves because of their race? Well, I don't think anybody disagrees that you should not be teaching children that they should feel bad because of their race, regardless of their race. Kids didn't do anything wrong. They're just kids. So parents have been going to school board meetings a lot, and some parents maybe have been taking this too far. Apparently, there have been threats that have been recorded by different school board members, and local law enforcement agencies, as they normally do, are investigating threats. So what today's legal aspect, I want to talk to you about this, is why did the National School Boards Association send a letter to the federal government trying to get the federal government involved in local school board issues? Well, first off, you have to understand the difference between federal and local law enforcement. If there's a threat, that's a criminal law issue. You have freedom of speech under the First Amendment to petition the government for redress, grievances. And you can go to these meetings. You can say, I disagree with you, X, Y, Z, but you can't threaten people, right? You can't say, if you don't change this critical race theory thing, I'm going to shoot up the school, right? Bad deal. Can't do that. So if anybody does that, then they could be reported to their local law enforcement, because the Constitution gives the state governments, and the states then give local governments the power, what's called the police power, to regulate health, safety, and morality in their jurisdictions. And so this police power has been expanded to the federal government, but it's in a really limited scope. So the federal government doesn't just have a general police power. The federal government can only provide police enforcement, law enforcement through the FBI if a couple different things are present. One, if it happens on federally owned land. So if it happens in Yosemite National Park, they have federal jurisdiction. If it happens in Washington, D.C., they have federal jurisdiction. If it happens near the border, like of the United States, a port, like in Louisiana, New Orleans, bordering, the Gulf of Mexico. If it happens in the Rio Grande Valley, near a border security check, they're going to have federal jurisdiction because they have the responsibility to maintain national security and border security, whether they do or not. But in any case, they're going to have that authority. So the only time that they can get into the criminal law field inside the United States is, again, federal lands like Yosemite, or if it relates to interstate commerce. And so this, if you don't know about, if you're not a lawyer, you've never been in a constitutional law class, you probably haven't heard about the Commerce Clause. But the United States Constitution has this section that says the federal government has jurisdiction over things that affect interstate commerce. It has the ability to regulate interstate commerce. So there's interstate, I-N-T-E-R, meaning stuff that happens between two states over the border, and intrastate, I-N-T-R-A, state. That's stuff that happens wholly within a state. Almost all of federal criminal law is based on the Interstate Commerce Clause. Well, this activity like bank robbing is illegal because it has an effect on interstate commerce. Racketeering over 3 or 4 states is illegal because it has an effect on interstate commerce. If you don't have an effect on interstate commerce, then a federal criminal law, again, if it's not on a federally owned land, is going to be unconstitutional, because the 9th and 10th Amendments secure all the powers that are not granted to the federal government. They're secured to the states or to the people, respectively. So that's why there's all this, tumult about this letter, because if we look at the NSBA letter, I've got it pulled up here. They sent this letter on September 9th. They said America's public schools and education leaders are under an immediate threat. And they said this, and this might strike you as odd unless you just listen to what I told you about the Commerce Clause. The NSBA believes immediate assistance is required to protect our students, school board members, and educators who are susceptible to acts of violence affecting interstate commerce because of threats to their districts, families, and personal safety. Does the NSBA care about the effect on interstate commerce that these acts of violence are going to have? No, they don't. They care about their school boards. They care about not being, obviously having people threatened is terrible. You don't want that. But in their letter, they say that they've already reported it to local law enforcement agencies, but I guess they're just not satisfied with the local law enforcement agencies' efforts in those cases. So they want to bring the feds in. So what's the line that's been cherry picked out of this is the following line, okay? As these acts of malice, violence, and threats against public school officials have increased, the classification of these heinous actions could be the equivalent to a form of domestic terrorism. So Republicans in the Senate have said that this is the NSBA saying that parents who don't want critical race theory taught in school, those are domestic terrorists, and the FBI should investigate them. Okay, so why did the NSBA write domestic terrorism in here? Well, I guess maybe it's because they felt that way, but probably not. To me, it looks like they've got this line here about it's affecting interstate commerce, and then they're like, we know that that's not a great argument, because how does a individual school board meeting itself affect interstate commerce? Maybe the school board members would be less likely to eat at chains like McDonald's, which have greater risk of them being exposed to members of the public and are interstate commerce entities. Like maybe you could string it in through that, but boy, that's really tenuous. It really doesn't affect interstate commerce, so they know they got to have another hook. So what's the other hook? Well, the Constitution says that the feds can get involved because they have the right to protect us from all threats, both foreign and domestic. And domestic terrorism, if you classify the parents as domestic terrorists, then all of a sudden the Department of Justice could get involved. And it worked. Merrick Garland on October 4th issued the letter, the memo. It's a 1-page memo. You can look it up. It's very easy to find. Just look up Merrick Garland memo. And it's titled Partnership Among Federal, State, Local, Tribal, and Territorial Law Enforcement to Address Threats Against School Administrators, Board Members, Teachers, and Staff. And so all it says is that to this end, he's directing the Federal Bureau of Investigation, working with the United States Attorney, to within 30 days of the memorandum, facilitate discussions for strategies for addressing threats against school administrators, board members, teachers, staff, and will open dedicated lines of communication for threat reporting, assessment, and response. So that's the issue there. Merrick Garland is getting hauled in front of Republican senators to be questioned about this so that they can make some hay about whether or not you're classifying these people as domestic terrorists. When you look at it from a legal perspective, the real root of the problem is that the federal government has this power to have a general police power that's not really contemplated in the Constitution, and the ability to act entirely on behavior that occurs inside of a state, as opposed to only behaviors that occur between states. And so if the Supreme Court had not ruled in Wickard versus Filburn that, for example, in that case, a wheat farmer, and I think he had pigs on there too, but a wheat farmer couldn't sell his wheat without complying with federal regulations, even though he never sold any of his wheat outside of his own state. It was totally intra-state commerce. The Supreme Court said, well, it could have an aggregate effect, because if he sells his wheat totally in-state, that could affect the price of wheat all over the country if him and other farmers like him were taken in the aggregate, and the federal government gets to decide, things like that. Maybe that was a little too far in that direction, and it's led to all this this using of the federal government in this way. And so if you're hearing about this and you're upset about critical race theory, I just wanted to point out as well this legal underpinning here about the Commerce Clause, give you a little information on that, and let you ponder on that for a little bit. So thanks for joining today, and subscribe, like, shoot me a comment, and if you got an idea for a video, I can do one in the future. If you've been concerned about a legal topic, we'll maybe discuss it on here, or something in the news that you've seen. Feel free to leave a comment and we'll discuss that. Thanks. We'll see you later.